Hey, Brian Parker here, coming at you with a good one. Hey, this week we've done 2 videos, how to handle debt collection letters that the CFPB has created and I wasn't too happy about, but I told you how to break them down and beat them and not follow the CPFP rules. And then I told you how to handle verbal calls from debt collectors. And this video, the finishing of the 3-part series, is going to be understanding your rights under the new CFPB debt collection rule. And it got it right. I think it got it right. It's handling things. The debt collection, the FDCPA was created in around 1977. And only old guys like me were around. There weren't emails or texts or any of the social media that there are today. So the CFPB decided that they have to catch up to the rest of the world. And on November 30th, 2021, they came out with new rules that they called the debt collection rules. And they were just putting spins, like I told you in that first written video, on an old rule. So they brought it into the 21st century, way into the 21st century, and effective November 30th, 2021, the CFPB has made a change to a rule that's covered. It's been the lion's share of my practice for 30 years in federal and state courts. I'll just give you that rule, federal rule, real quick, Shazam. 15 U.S.C. 1692C, and that covers really 3 things. That it is illegal without prior consent, and remember prior consent, to contact someone at an unusual time or place, or time or place known, which they should have known is an unusual thing to do. But within that part of the rule, that subsection, you're not allowed to call someone from 8 a.m. to 9 p.m. their time, meaning at their location. So if you're calling from, your debt collector calling from California and it's 6 p.m. your time, so it's going to be 9 p.m., 9:30, that's verboten, that's illegal. So it's your time, 8 a.m. to 9 p.m. Secondly, if the debt collector knows a consumer is represented by an attorney, you can't contact them. Number 3, you can't contact someone at their place of employment if you've advised the debt collector that you can't do that and you're not allowed to take calls. We'll get more into that. And also, there's a privacy aspect to this. You can't make your business, the debtor's business, available to third parties, whether it's answering machines or social media or anything like that. We'll get into that. And you've got to cease and desist debt collectors once we send you a letter saying as such. So attached to the video will be a cease and desist letter, a cease and desist letter specially designed for you for stopping work calls, an end of contact, authority contact. What is that? We're going to get into that, but you, when you sign up for a card or a loan, you gave your prior consent to be harassed. So we're going to show you how to get out of that with the new rules and a new letter from me, plus my show notes. So how often can debt collectors call under the new rules? Well, it's a 7 calls in 7 days rule. So the rule is, it is illegal under the new debt collection rule to call more than 7 times within a 7-day period, and they cannot call you within 7 days after they've already had a phone conversation with you. So the debt collector calls you and go, hey, is that your debt? You go, I don't know who you are, cease and desist. They have to wait another 7 days to contact you again. Let me break that down. So if a debt collector calls you on a Monday and speaks with you about your credit card debt, they cannot call you again until the following Tuesday. They call you 5 times in 1 week, but you never answer. They can call you 2 more times, but that's it. After the 7 call limit, they hit their limit. So that only applies to phone calls. That doesn't apply to social media, text, email. So, but there are protections. Again, as I said before, they can't call you between 8 a.m. and 9 p.m. They can't call you at your place of employment. If they know you're represented by an attorney, can't touch you, can't touch that. And at any place you specifically told them, or they should know, is inconvenience. If they're aware that you're at church or at services or something, and they purposely call you, well, they're aware you can't take that call. It's a form of harassment. So let's look at the difference between text and emails and phone calls. Here's where it gets interesting. Phone calls have this limit, but the CFPB did not put limits on emails and texts. However, but this is big, they still cannot harass you. So if they send you 20 texts in a day, every court in the land will say that's harassment. It's now not a rule that is being violated, it's fact specific, but every court will go 20 times in a day, and he also says he told you to stop calling him and you continued, that would be a violation of the FDCPA. So remember the prior consent rule that I told you about when you signed up for credit card debt or a loan, you automatically say to them, you have the right to email me, text me, all this stuff. So keep an eye on that. How do you opt out of something where it's not covered by the FDCPA as far as voicemails or emails? Here's one of the most important parts of the rule. Every single electronic communication has to have an opt-out provision. So you know what I'm going to say to you. It'll say, hey, we think you owe us a debt. It's $550 to a medical debt. But however, reply stop to stop text. It must have that, or it must say, click here to unsubscribe. An opt-out method must be what the rule calls reasonable and simple for you. Meaning, let me give you some examples. A clickable link on an email, that's good. That's reasonable and simple. Call this number to opt out, it's acceptable. I don't know why you should go to the trouble, but the CFPB says you should. Mail us a letter to opt out. That's not acceptable for electronic communications. For electronic communications, not that stuff we talked about earlier. Go to our website and opt out. No, that's not reasonable and simple to do. You don't have to use their method, by the way. They can say, you know, stop this way. You can use any method you want. You can write stop, unsubscribe, end, quit, cancel. So let's put a list up there. Common opt-out terms, ways that you can unsubscribe. Stop, unsubscribe, end, quit, cancel. Once you opt out, they're entitled to only one more message to you saying, we got your request and we'll honor it. They cannot email, text you, social media you again. But the social media rules, you want to know social media rules regarding Facebook, Instagram, Twitter X, LinkedIn. So this is the rule. You cannot display things no matter what the forum where a third party understands what's happening, okay? So if a debt collector sends you a friend request or a connection request on social media, they must identify themselves as a debt collector right in the initial request. They can't pretend to be someone else. They cannot be viewable by the public or your friends. So they can't post on your wall or comment on your post. It has to be a private direct message notifying you that they are debt collectors. Every message must include an opt-out provision. And if a debt collector messages you on Facebook and your spouse sees it, that should be a problem for them. They have to be careful about third-party disclosure. So while there are specific hard and fast rules for how you handle or how many calls or letters you receive and the form of those letters, while text messaging, electronic messaging, Facebook stuff, social media, oh man, that doesn't have hard and fast rules. Harassment is always harassment. And including work. If you're receiving emails at work, the debt collection rule specifically prohibits collectors from using employer-provided email addresses. Remember that. So if your email is john.smith.companyname.com, then they cannot send debt collection emails to that address. Verboten. So if they're calling you at work, I've got my special letter. You don't need my special letter. It's attached to this video. You can let them know verbally, hey, I can't take calls at work. I'm whatever you are. I'm a dispatcher. My boss gets mad when I take personal calls. Keep a paper trail registered by mail. Don't rely on other people to say, well, I'll just ask the debt collector. They'll say that I told them to stop. Said no one ever. So you have to do it in writing. And I've got a letter for you to send. Send one of my letters. Okay, so that's a cease and desist letter, at work call letter. I want to talk about limited content messages. That's kind of a safe harbor. Remember we talked about earlier, I don't know if you remember, but in my written one, the CFPB gave out a safe harbor letter which I blew up and tore up and scalpeled it to how bad it was for you, the debtor, and to depend on my letters if you want, because it was a click box, hey, I dispute this, which didn't describe any reason why they should stop, and it actually hurt you. I'm saying CFPB got this section of the new debt collector rule right, and they've limited what you receive in voicemails. It must say a business name that does not indicate they're a debt collector, a phone number you can use to call back, a request that you reply, and the names of people you can contact. The rule says they can give a greeting, the date and time, suggest times to call back, that you can speak to any representative, but it must not be obvious that it's a debt collector calling. You've had those calls, I've got a business reason for you to call back, stuff like that. It cannot be where an average person go, hey, that's a debt collector call. So they cannot include any mention of the debt in the call. Remember, this is a limited content message. The words debt collector or debt collection must not be anywhere in the call. Any identifying information about why they're calling cannot be in the call. So that's limited content message, and it is designed so that a family member or a third party, as the rule requires, does not understand that call. This only applies to voicemails, however. It doesn't apply to text messages, emails, and social media messages. But different rules help you and protect you and do apply. So you know about the validation letter numerous times. I'm not going to get into that, but there's an aspect of that that I want you to hear about. So I want to talk about consent. Again, when you took out a credit card, a car loan, a personal loan, a fintech loan, you agree. You know, we all have this 15-page credit card agreement. We just want to get the credit card so we go buy something. But it says we can call you, talk to you at work, whatever it is. It's very one-sided. So that's called prior consent. You've consented to receive calls long before this thing turned into a debt collection mess and a debt buyer bought it or thought it did. So I have a message for you. Revoke that consent. The first time you get a call about a credit card, even if they're not invoking prior consent, your first, one of the letters is the revoking of the prior consent letter. So I will attach this video, an end of authority. You cannot contact me, and it'll be right there on killdebt.com, attach this video, and I'll embed it, of course, in Parker GPT. So that end of authority letter is something you need to grab a hold and send out no matter what the situation when a debt collector calls or contacts you. So how do we prove our case if we have a good case against them for violating these new rules? We document, keep a paper trail, register by mail. But what I want you to do, using the technology that the new rules are recognizing, screenshot everything, even I know what that is, save your voicemails, keep a call log, document every harassment pattern as you see it, note the time zone that you received the call. So they're saying, hey, we're from California, it's only 6:30 here. Note that they said that, who said that, what number it came from, and what time it is when you really receive that call. And you can do that a number of ways with screenshots. Save opt-out requests. Again, keep a paper trail, register by mail means keep everything. So if you opted out, screen test, just save everything. And if they send you something and they are missing opt-out notices, save that. It all helps you either settle a debt in a better way or sue them for violating the law. So one of the things, here's some list of things you can do, half of which I don't agree with. File a complaint with the CFPB. Okay, I'm going to say this to you, will go nowhere. Report them to the state attorney general. Okay, they'll just get right on. No, they won't. Sue them for FDCPA violations. Yes, that's what you do. That's the best thing you can do. It's the only thing a bully understands is be a bully back. This third party, attorney general, CFPB, they got too many other things on their hands. Trust me, it's very political there. I'll leave it at that. So you want to download my cease and desist letter, cease and desist for work calls, my end of authority letter, and look at my show notes. And you will be in great shape to keep up with the times like even the CFPB did by bringing the 1970s to the 2020s. I still don't know a good way to refer to the current decade, but whatever. So that's you keeping up with the CFPB that's handed out some really good rules that are about the social context that we now live in. We live in social media, but while the debt collectors are jumping right into that, and you better believe, while you may not believe in AI, debt collectors believe in AI and it believes in you. So your best shot of staying in your debt defense lane is killdebt.com and Parker GPT. It's got a million cases in there. It's got all this 30 years of litigating and all the forms that I bring you, all embedded at a click of a mouse. You have the perfect AI defense against AI rangers that are coming your way. So let's use the rules, let's use Parker GPT, and let's go get these guys. Thank you.